Good afternoon, everyone. Today, I will be arguing for the defendant with specific reference to the use of intermediary for the entirety of the trial. To summarize the facts of the case, the defendant had been awarded an intermediary solely for when he was giving evidence on the basis that he was not mentally vulnerable despite the findings of qualified expert medical witnesses. His IQ level had been established to be at borderline low at a range from 70 to 79. Regardless, it was determined that there was absolutely nothing to suggest that he could not take part in the trial fully or understand everything that was going on in spite of his mental capacity. As such, this brings me to my first argument, that would be that the judge erred on his judgment that Rashid required an intermediary only while he gave evidence, and that too on an over-generous basis. Despite expert evidence provided that the applicant would be unable to participate in the trial unless he was supported by an intermediary, the judge ruled that Rashid did not warrant the assistance of an intermediary throughout the trial. This is in direct contradiction of Article 6, the right to a fair trial. Without an intermediary, the defendant is unable to effectively participate in his trial. He is unable to answer questions with a complete understanding of what has transpired. This defies the principle of accurate fact-finding. As explored in the guidance on using special measures by the Ministry of Justice, it is said that each individual is entitled to give his best evidence. Given that he was in a position comparable to someone who could not even speak English, he could not possibly be able to follow an entire proceeding without any assistance. Clearly then, there is not an environment for accurate fact-finding, especially with his tendency to yield to leading questions and change his answers with regard to negative feedback. As per Criminal Practice Direction 3D.2, the court is required to take every reasonable step to facilitate the participation of any person, including the defendant. In this case, I submit that the court had failed in doing so, blatantly denying Rashid the right to a fair trial. Secondly, the role of the expert witnesses and their importance was undermined as well. It was emphasized that the judge had been right to overrule the decisions of the expert witnesses, and this would have been the case even if the experts agreed on their views. It is unfair to place such insignificant value on their opinion given their expertise and experience. As Dr. Hathaway puts it, Rashid appears as more able than he actually is, and this is hard for any medically untrained individual to confirm. In R. v. Everett, the judge had erred in failing to consider medical evidence ascertaining the importance of medical reports in this current case. It was added that what was material was not what the officers thought of the appellant's mental condition, if they gave it any consideration at all, but what the mental condition of the appellant actually was. This statement must be considered in light of what the judges felt in Rashid's case when they claimed that the appellant had no evidence of specific difficulty. The actual physical and mental state should matter above perception. Thus, the decision should have been based on accurate fact-finding, which it was not, and more so on the observations of the judge. This relates to my next point of competency of lawyers representing vulnerable defendants. The judge in this case had clarified that the court must take into account that the advocate had undergone specific training and that the experience enabled him to conduct the case in accordance with proper professional competence. Although in Rashid's case it was felt that the advocates were competent, it is a difficult determination to make given that the level of competence must be consistent throughout the trial. This is especially so in the case of vulnerable witnesses whom are not easy to assess. As such, there is an overlying dependence on advocates to be sufficiently competent when denying intermediaries, and my argument is that more often than not, this is not enough. As stated in the Law Commission's report Unfitness to Plead, there is an insufficient awareness and understanding of communication difficulties and how they can be identified and addressed among some legal practitioners and judges. While there is an argument that the advocates are competent enough and that the judges will intervene when necessary, these provisions are not sufficient to ensure that the defendant can actively participate in the trial and fight the case to the best of his ability. As pointed out by the Lord Chief Justice in the case OP, the overwhelming majority of cases, competent legal representation and good trial management will be enough to make sure that the defendant gives best quality evidence, participates in the trial, and receives a fee. a fair trial. However, as highlighted by David in the Criminal Law Review 2017, there has been very limited training with respect to vulnerable witnesses. Further, the accreditation can be obtained simply with attendance that is not even mandated by the bar's code of conduct. Referring back to Rashid's case, it was noted that an advocate that could not carry out basic tasks was in serious dereliction of duty to the court. However, this still does not mean that they would have been considered to have breached their professional duty. The expectation then is that barristers should refuse such cases, placing a huge responsibility on them. But in most situations, this is not the scenario. There is still another safeguard that remains where a judge is expected to intervene and correct the error in circumstances where the advocate is not competent enough. As seen in R.V. Cox, the court adapted to the process and the judge ensured the defendant would still be able to follow the proceedings even in the absence of an intermediary. It should be noted that an intermediary had been awarded but was unavailable. In Rashid's case, therefore, it is unjust to completely refuse him such a provision. And while this case did establish that providing an intermediary is not mandatory, it is crucial to note that it explained that the use of intermediaries in appropriate cases made a valuable contribution to the administration of justice. Thus, the intervention of a judge should only be a safeguard for failure to provide intermediary, especially in the present case where Rashid was operating at a low level of social cognition, and to deny him an intermediary is to deny him his right to a fair trial. Additionally, the explanation of court processes during trials can be viewed as an overstepping of their role as an impartial and unbiased judge, which is an important component of a fair trial. To add on, the role of the intermediary is not one that can be easily replaced. As David accurately captures, it involves an ongoing process of assistance, specific knowledge on vulnerable individuals so as to be able to take account of their mental, physical, and emotional state. Given that the intermediary is seated with the witness during trial, it provides an opportunity for the intermediary to quickly notice any issues. Arguably, neither an advocate nor the judge is able to devote such a level of attention to the vulnerable defendant. As Rafferty LJ notes in OP, this is a role that involves skilled support and interpretation with the potential for intervention and on occasion suggestion to the bench associated with the giving of the defendant's evidence. This is one that requires an intermediary as Rashid should. In fact, this is made worse by statutory limitations that exclude vulnerable defendants in readily having access to special measures. In other words, Section 16 of the YJCEA applies to witnesses but excludes defendants. While it may be argued that a provision for defendant witnesses exists in the form of Section 109 of the Coroner and Justice Act, not being enforced meant that the power to appoint lay with the judge and the court's inherent power at common law. This highlights an already existing inequality of arms. As held in the OP case, the individual in jeopardy in criminal cases is the one who is facing the charges and not those who attend as witnesses. Therefore, they deserve an equal standing at trial and should be provided with intermediary so as to be in the best position to do themselves justice. As rightly pointed out in R.V. Great Yarmouth Youth Court, there is a right which may in certain circumstances amount to a duty. Therefore, such a denial to use special measures for the duration of the trial would lead Rashid to be solely dependent on the trial process for protection. Given his educational background and his lack of mental capacity, he still faces difficulty in understanding and following the rest of the trial. As brought up in the Sevenoaks case, it was felt that although he understood the charges against him, he would have great difficulty with the trial process itself, and this would have a detrimental effect on his ability to concentrate and absorb a high volume of information. As discussed in the 2013 Criminal Law Review, this can worsen the feeling of stress and confusion, isolating the defendant from the trial. This is in clear contradiction of Article 6 of the ECHR, the right to a fair trial where fairness means active participation. To conclude, Rashid should be provided with an intermediary so as to allow him to actively participate in the trial and ensure accurate fact-finding. At the same time, this would put him on par with other parties in the trial and effectively provide him with the right to a fair trial. It is also unfair to have to depend on the trial process and the competency of advocates to replace an intermediary.